We will be covering a wide range of topics that businesses definitely need to know about. Today, we will review the upcoming state privacy regulations along with some latest updates. We will also analyze the similarities and the differences between these regulations. We will go over some practical considerations to help businesses achieve regulatory compliance across multiple states. And at the end, we will leave you with actionable insights to future-proof your business for 2025. We will also address the questions posted in the chat at the end of the session. Great, let's jump right into today's presentation, and I will turn it over to Kelly with this question. Kelly, could you take us over the laws which are already in effect this year and those that will go into effect later this year?
Yeah, sure. I know it's this conversation is always evolving a little bit, but if we start with the laws that are in effect right now, we have, of course, what I think of as the original five. California, the CCPA has been later modified a few times. Virginia, Connecticut, Colorado, and Utah. And then, we kind of move into the 2024 states. So Florida, Texas, and Oregon went into effect July of last year, Montana in October, and then we move into 2025. So now we're getting a little bit of a landslide. As of January 1 of this year, Nebraska, Iowa, Delaware, and New Hampshire went into effect. New Jersey on January 15th. So that's where we are right at this moment in time. But if we came back and did this webinar in a few months, we have Tennessee coming into effect July 1st of this year, Minnesota on July 31st, Maryland October 1st, and then three more in 2026, Rhode Island, Kentucky, and Indiana, beginning of next year. So that's what the landscape looks like now and sort of through the rest of 2025 into 2026. But if past patterns hold, we'll have another 5 to 7 laws probably coming into effect sometime, maybe in the latter part of this year, the beginning part through, mid of next year. So the map continually changes. The patchwork is getting a little less patchy. We have more areas filled in, but that's where things stand as of today.
Brilliant. And what would you say are the commonalities between these laws?
Yeah, there's so much in common. And I think I actually just read, thinking about our patchwork, that we've reached a tipping point where more than 50% of US residents are covered by a comprehensive privacy law in their state. That's an unverified statistic that I read online, so don't quote me on that one. But I don't know, that seems to make sense to me. I think these laws still have maybe more in common than they don't. And I think from a practitioner's perspective, we are still able, with a couple of really prominent exceptions, to have a sort of single compliance path that covers almost all of the obligations under these state laws. So just to highlight some of the similarities, first, there are the thresholds. Almost all of these laws, I'm probably going to say almost all in a lot of instances, but almost all of them have thresholds for applicability that's tied to the volume of data that's processed in a state or sold. There are prominent exceptions to that, including Florida, which has a very unique threshold, and Texas, which doesn't kind of adopt that same framework. But that is still largely true, that there are thresholds for processing that are intended, it maybe not successfully, to carve out kind of the smallest of small data processing businesses. They all have very broad definitions of personal data, and they all implement sensitive data definitions that have a lot of common elements across them. Although, of course, states here and there, some will add some very unique data elements to sensitive data elements. They all feature fairly broad exemptions. With the exception of California, all of the states exempt kind of HR data and B2B or professional contact data. There are broad exemptions in all the laws for data that's regulated by other privacy laws like HIPAA or Gramm-Leach-Bliley. In some states, those are sort of entity level exemptions where if part of your business is regulated by one of these regimes, all the data is out. And others, it's kind of that particular data stream. But you do have the benefit of those exemptions. Kind of entry level exemptions, like, do we exempt nonprofit organizations? That's one that's been chipped away a little bit, where it's, more of a mixed bag. All of these laws sort of preserve that controller processor dichotomy that we're all familiar with from other global privacy laws. Of course, California calls it business service provider, but that kind of notion of an entity that's primarily responsible or obligated under these laws because they have the means and method of controlling the data versus their vendors or service providers who are largely obligated via contract. That's preserved in these laws. I think most importantly, all of these laws remain laws of kind of notice and consent, either, opt in for sensitive data or certain data processing operations, or opt out for things like basic data sales. But that framework is largely true across all 20 laws. They all have individual rights. Of course, there's some squishiness in which rights are offered in which states, but you have that kind of core fundamental base of rights of access, deletion, that is uniform across all of the states, the rights to opt out of sales and certain kinds of processing. And then some kind of governance pieces. So, requirements for vendor contracts, requirements for assessments of certain high risk processing activities, not fully uniform across all 20 states, but I think, fairly broad and expected in these laws. So I know we're going to talk about some of the differences, which really are crucial and are starting to emerge this year. But we're still in a position where when a new state has come online, there's kind of a core playbook or a core set of menu items that the state laws are based upon. So we have yet to have a state really choose to break the mold. There have been some proposals that would have done that, but we haven't seen that yet. And, where I started, you're still able, if you have to comply across the board, to chart, for the most part, a single compliance path, if that's desirable to your organization, where you're not kind of treating different states, differently, where you have a real true kind of patchwork approach.
Great. Thank you for that fantastic overview, Kelly. That was great. Turning to you, Daniela, what would you say are the key differences between these laws?
So yes, as Kelly was saying, U.S. consumer privacy laws have a lot of commonalities, but each state adds their little unique twist to it. So I'm going to start with consumer rights. One of the most known key differences in that in the consumer rights realm is that the right of correction is not included in Utah and Iowa. And other difference is that the right to obtain a third-party list is only included in Oregon, Delaware, Rhode Island, and now possibly in Connecticut if these amendments are enacted. But the most unique one is Minnesota. So Minnesota added a completely new right, which is the right to contest profiling results. So this right implies that individuals are allowed to request an explanation of such results, to review the data that was used to reach such results, to require alternatives of what they could do to obtain a different outcome in a future opportunity, and to basically request explanations of the reasoning behind a decision. Other states have included specifications or additional clarifications to common rights. For example, in California, for the right to opt out of sales, they have clarified that when individuals have preferences regarding that right, and such data is obtained later by another controller through a merger and acquisition or bankruptcy or similar transactions, the organizations have to respect such previous the previous intentions of the consumers. Other example is Maryland for opt-out request. This state doesn't allow organizations to reject opt-outs based on suspicions of fraud. And another one is Maryland and Rhode Island, which are the only states that include a specific time frame to cease processing after a consumer has withdrawn their consent. So Maryland is set at 30 days, and Rhode Island has a time frame of 50 days. Other key differences within this consumer privacy laws are found in privacy notice requirements. Each law has like a laundry list of all the disclosures that organizations need to do or to include in their privacy notices. For example, some have the requirement to have an active email included in the privacy notice, the contact information of the controller, or a statement regarding the collection or processing of sensitive data or biometrics. But I want to highlight a specific one, and as Minnesota. Minnesota require organizations to have in their privacy notice the retention policy. So this is very unique because in any other consumer privacy laws, there's an explicit requirement to have a retention policy. So Minnesota here is kind of implying that you have that requirement in that state. And other states have included like a different type of privacy notice for specific scenarios. So for example, Maryland, they include a notice for third parties when those third parties are using or sharing personal information in a way that is inconsistent with the promises that were made to consumers. And in those cases, they have to provide notice with these new changes or with new processes that are going to be implemented before and with a significant amount of time before implementing those processes, so the individuals can exercise their consumer rights if they decide to. Another example is Rhode Island. They don't have a general requirement as all other consumer privacy laws have, like a general requirement to have a privacy notice, but they referenced that requirement in another section of their law. So it's kind of implied, but they don't have like that laundry list that I mentioned as the other states. But they do have a prescriptive privacy notice requirement for commercial websites or internet service providers when they have business in the States, when they have consumer in the States, and when they collect, store, and sell personal information of consumers. And also like that privacy notice is very specific, like it needs to have like all the categories of data that are processed by these websites, all the third parties that might have that the organization might disclose the data to, which is kind of weird because an organization can't like know eventually which to which organizations are going to disclose this data. And it has to be in their website in a conspicuous location. Another key difference in the consumer privacy laws is the data minimization standard, specifically in Minnesota. So could you explain us the challenges with this new standard in Minnesota?
Sure. So what I've been paying closest attention to is a new data minimization standard in Maryland, actually, so a different state. And I think it is important to distinguish Maryland, one of these new comprehensive privacy laws taking effect this year, from what has come before it, because Maryland really does represent potentially a paradigm-shifting approach to consumer privacy at the state level, though I do use that term potentially deliberately. I'll first set kind of California aside, which has its own approach to data minimization and purpose specification through Section 7002 of that law's regulations, which really ties what data you collect and how you can use it to the reasonable expectations of your customers. For most other state privacy laws, they say that businesses need to determine upfront and disclose what data they collect and how they will use it. Now, some people argue that that approach in state privacy laws basically just incentivizes companies to bury any possible use case of personal data deep within privacy policies that basically no one will ever read. But on the other hand, it does seem to shut down the potential for businesses to just scoop up whatever data they want on the off chance or assumption that they may find a use case for it later. Now, the common approach of these state privacy laws also is that for collecting and using sensitive personal information, think your healthcare information, biometrics, precise geolocation data, businesses need to obtain opt-in consent in order to collect and use that data. And that opt-in consent must be freely given, specific, informed, and unambiguous. Now, that's a very high kind of European-inspired standard, though it does kind of remain to be seen how it will be interpreted and enforced in a US context. So that is kind of the current landscape, and that is where the Maryland Online Data Privacy Act comes into play. ModPut basically implies that it doesn't really care so much about your data disclosures. It doesn't really care so much about consumer choice. In fact, Maryland implies kind of that notice and consent is dead and that people get so many pop-ups every day that they'll never really be able to make informed decisions about their data and privacy. So instead, Maryland seeks to tie what data can be collected and how it can be used to the nature of the product or service being offered. And there is a three-part data minimization standard in Maryland. First, the collection of personal data is required to be reasonably necessary to offer a product or service requested by a consumer. Second, processing, which includes collection, use, and sale of sensitive data, requires it to be strictly necessary to offer that product or service requested by the consumer. And third, the sale of sensitive data is presumptively impermissible, though there are some exceptions in the law. Now, if anyone thinks they may be regulated or they're generally interested in the Maryland Online Data Privacy Act, I encourage you to spend some time digesting these provisions. However, I would put it to you that if you want to understand Maryland's data minimization standard, you need to be able to answer my riddles 3. So I have 3 riddles in riddle 1. I've mentioned a reasonably necessary standard for processing and a strictly necessary standard for processing. However, these terms are not defined, and it will be left, at least initially, to companies to figure out what they mean. What's the difference between reasonably necessary versus strictly necessary for processing? And is using personal data for advertising or to train AI models, for example, ever necessary to offer a product or service? Riddle 2. Let's say you do decide to treat Maryland like other states and you obtain opt-in consent to process personal data for a particular activity. Does that activity then become a requested product or service under the Act? And if so, does Maryland's attempt to move us beyond the traditional notice and consent approach actually kind of collapse back into notice consent and could end up with individuals seeing far more pop-ups and privacy notices? Riddle 3. These standards have been inserted into kind of a traditional Washington Privacy Act style framework that is based on consent. And the law still provides that you can process data for a previously undisclosed activity if you later obtain consent for it. So would that actually encourage businesses to offer fewer disclosures if that standard then overrides the consent standard? So I've spoken to a lot of people about this law, and to date, no one has been able to answer all of my riddles. But I do think that many of us in this space are waiting to see how the Maryland Attorney General plans to interpret and enforce these provisions, because, as I argued at the front, they are potentially paradigm shifting in the state privacy context.
What do you think about the 2 bills that are currently Maryland and Connecticut that are planning to change places right now?
Sure. So a lot of folks have looked at Maryland and said, whoa, this doesn't make much sense to me, this doesn't necessarily seem workable, will there be an amendment to the law to kind of polish up or clarify this new data minimization standard before it goes into effect? So enter HB 1365 in Maryland, which is a proposed amendment to MODPA, which would essentially standardize just that first plank of Maryland's data minimization standard that I mentioned. And it would say that to collect personal data, you need to be transparent in doing so, which is kind of the common approach. But I do have to throw cold water on anyone hoping for a substantial rewrite of Maryland's law before it goes into effect. This bill has just been sponsored by only one lawmaker. It won't have its first hearing until next week, and it would only impact what is essentially the narrowest element of Maryland's novel data minimization standard. It wouldn't impact those stricter restrictions on the collection and use of sensitive data in Maryland, which sensitive data in Maryland, very broadly defined. But what is ironic, and that you mentioned, is that as Maryland considers HB 1365 to standardize its collection standard with the rest of the country, Connecticut is considering SB 1356, which would change the Connecticut Privacy Act's data minimization approach with respect to the collection of data to make it match Maryland's existing standard. So essentially, Maryland and Connecticut are proposing to trade places with respect to this one very specific but important requirement. Kind of just like the 5 and the 6 are switched between these two very similar bill numbers. Now, I do want to flag that Connecticut's SB 1356 is much broader, would have many more amendments to Connecticut's privacy law than just data minimization. It would expand the Connecticut Privacy Act's applicability. It would change the knowledge standard with respect to children's data privacy protections. It would drastically expand the definition of sensitive data under that law. It would require businesses to disclose a specific list of third parties with whom they share personal data, very similar to Oregon, which we've mentioned earlier this call. And it has momentum, it seems. It has been introduced in the primary committee of jurisdiction in Connecticut, and it has its first hearing tomorrow morning, 10 a.m. I unfortunately will be on a flight at that time, so someone in the audience, please take notes and send them to me.
Thank you for that. Great insights. Really, in addition to the differences that we already discussed, could you cover other variations of these consumer privacy laws?
Certainly. And we are seeing the trend of, in terms of differences, we are seeing a trend of increasing scope of data protection assessments. And there are a lot of differences because, for example, Colorado and Virginia, they both require DPAs when companies are processing high-risk data, especially minors' data or biometric information. They also focus on activities like profiling, where businesses must assess risks before proceeding with processing these types of data. California, on the other hand, they don't really have a specific DPA requirement, but it still emphasizes transparency when it comes to processing sensitive data. This is especially important for high-risk data processing, so data related to minors, health data. That's where businesses need to inform consumers about the data that is being used and how it's being used and the data that's being collected. These states want businesses to assess the potential risks before diving into processing. And like Care covered, Connecticut and Maryland are adopting a stricter stance, particularly around health and geolocation data as well. And Maryland stands out because they've banned the sale of children's data outright, and they're also limiting sensitive data processing to only what's absolutely necessary. The other area where we see some stark differences are in terms of opt-out signals and opt-out mechanisms. So some states like California and Connecticut, they have mandated compliance and they require organizations to honor universal opt-out mechanisms. But other states are providing businesses with more flexibility in how they recognize these signals. but it creates an inconsistent landscape for compliance. So for example, like I said, California, Colorado, Connecticut, Texas, they all require businesses to honor global privacy control, which is a universal opt-out mechanism. But this means that companies operating in these states must implement systems that automatically recognize and respond to these signals and stop processing personal data for targeted advertising and selling. So not only will this add a layer of technical complexity, but it could also impact ad-based revenue models. And when it comes to states like Virginia and Iowa, they do not mandate universal opt-out signal recognition. Instead, businesses in these states can ask data subjects to submit opt-out requests manually, such as through the company's privacy settings or through an online form. And this approach is slightly more flexible for businesses because they don't have to invest in automated recognition of opt-out signals. But on the other end of the spectrum, we have Tennessee and Indiana that have a more business-friendly approach that allow businesses to choose whether to recognize and honor GPC or global privacy control and similar mechanisms. And plus, these states apply revenue or data processing thresholds, as Kelly covered earlier, which means that only those businesses that are processing a large volume of data, for example, or exceeding a certain revenue threshold, they must comply with the broader privacy regulations. For example, Florida's Digital Bill of Rights only applies to companies with over $1 billion in revenue and specific data-driven business models, which significantly narrows its scope. And it also means that smaller businesses that are operating in these states may not be required to offer these opt-out options to data subjects at all.
Rita, you've covered differences in DPIAs and opt-out rights. Could you walk us through how different states are handling the processing of specific types of personal data, like children's information, sensitive data, biometrics, etc.?
Sure. So when it comes to processing sensitive data, and I think here already covered some of it, but we're definitely seeing stricter requirements in different states, but the exact obligations vary. In terms of children's information, like I said, Maryland has taken a more restrictive stance, and they have prohibited certain uses such as sale of children's data without parental consent. While states like Virginia and Colorado, they have introduced amendments that impose additional obligations in businesses that are processing minors' information, like carrying out DPAs. For sensitive information, Maryland also prohibits the sale of sensitive information and restricts its processing to situations where it's only strictly necessary. So these could be, for example, when it's a contractual necessity or with the explicit consent of the data subjects, or when it's for public safety. So those are the only cases when sensitive information can be processed in Maryland. And for California, on the other hand, they have introduced the right to consumers to limit how their sensitive information is being used, which adds another layer of consumer control. Another type of specific data processing that we're seeing some differences in is biometrics information handling. So Colorado has stricter regulations for biometric data under the Colorado Privacy Act, which requires businesses to implement additional safeguards and conduct DPAs like we discussed. But Illinois, on the other hand, allows consumers to sue for violations under Biometric Information Privacy Act, or BIPA, and Colorado empowers regulators for enforcement. So then there are also these other states like Texas and Washington that also regulate biometric data with varying consent and storage requirements. And California includes biometric data as sensitive personal information under CPRA and gives consumers control over its use. The last bit of specific type of data processing where we're seeing differences is consumer health information. So states like Connecticut, Maryland have introduced specific provisions on consumer health data. And Maryland imposes geofencing restrictions to prevent tracking individuals near sensitive locations such as reproductive health clinics. And both Maryland and Connecticut require explicit consent for sale of consumer health information. So while there are overarching trends, the details definitely vary by state, significantly vary by state. And I will actually turn it to you, Care. So in addition to the consumer health data requirements that we've outlined in these laws, we know there's an upcoming law in New York called the New York Health Information Privacy Act that closely resembles the Washington My Health, My Data Act. But it still has some key distinctions. Could you provide your insights on this new bill, Care?
Sure. So the New York Health Information Privacy Act, S 929, passed the New York legislature very rapidly earlier this year. And it is currently awaiting action from Governor Hochul, who does have flexibility to seek potential changes to the act before she decides to enact it, if that will be her decision. Through what is called the chapter amendment process, which exists in New York. As you mentioned, S 929 is of a similar scope and scale as the Washington State My Health, My Data Act that passed in 2023. But in some respects, New York would appear to go much further in its current form. I will assume some knowledge of the Washington State law on behalf of this audience in answering this question. But New York covers a very broad range of information that is processed in connection with health data, which could potentially be more expansive than Washington's approach to covered data. However, New York doesn't explicitly state that all biometric data is inherently health data, which Washington State does. But then, on the other hand, New York also lacks common carve-outs. So, for example, it doesn't exclude data used for public interest research. It does not exclude publicly available data. And it also lacks a carve-out for data regulated under the federal Gramm-Leach-Bliley Act. Washington State also has a default data minimization standard necessary for offering a service. However, New York has a strictly necessary data minimization standard for what data can be collected and used. So once again, we're seeing these new data minimization terms and standards trying to tie what data you can collect and how you can use it to the nature of the specific product or service you're offering. But we're still not necessarily quite sure what these terms will mean in practice. However, Washington does permit most other processing activities if a business obtains fairly standard opt-in consent. However, New York has a unique consent standard called a valid authorization requirement, which goes far beyond kind of traditional opt-in consent in US privacy law contexts. S 929 would require some very prescriptive steps for a business to take in order to obtain that valid authorization, including providing that authorization cannot actually be obtained from a customer or potential customer until at least 24 hours after a business first interacts with that individual. So that would be an entirely new requirement in a US privacy context, and it's not actually necessarily obvious how that would be supposed to work in practice. New York also has a unique requirement that all data processing activities have to immediately cease if a customer revokes their authorization for use of that data. And frankly, just knowing kind of the modern information environment, how data is backed up, stored, shared with service providers, seems very difficult to implement. And in most other states, there was a 15-day window to cease processing after an individual revokes their consent. New York does have some standard kind of consumer rights that we've mentioned, the ability to correct and delete or access and delete covered data. However, it does not provide a framework allowing businesses to verify that these rights requests are legitimate, which potentially could introduce new cybersecurity vulnerabilities. And this is especially pressing because the law provides that authorized agents can exercise these rights on behalf of customers, which isn't the case in many privacy laws. It's the case in California, but not elsewhere. Now, the good news for businesses, assuming that the New York Health Information Privacy Act goes into effect, is that while Washington State expressly provides for a private right of action for individuals to sue to enforce alleged violations of the Act. And by the way, we just saw our first class action invoking Washington State's My Health, My Data Act a couple of weeks ago. On the other hand, New York does not expressly provide for a private right of action. However, it does not expressly disclaim a private right of action either. So something to pay very close attention to on that bill as it reaches the governor's desk.
Besides this New York bill, which other privacy developments do you think could affect companies' strategies for compliance?
Thanks. I'll mention two, and I will try to be brief. One, we've talked about all these laws on the books, but we've also mentioned they can take a while to go into effect. They're passed, there's a delay before they take effect. When they take effect, there's often a right to cure period that lasts for another 1 or 2 years. And so we're still kind of at the outset of seeing regulators begin to enforce this kind of new era of state privacy laws. So at this stage, it is, I think, very important to see who are the active regulators and what are they focusing on. One very active regulator is clearly California, which has been very focused on whether or not businesses are providing opt-out rights with respect to targeted advertising. Texas over the last year has become an extremely active regulator, both under their comprehensive privacy law, the TDPSA, as well as other laws they have about biometric data, children's data, etc. And Texas has been focusing in very keenly on allegations of deficient notice and consent with respect to collecting and using sensitive data. And then two, I am also watching very closely kind of the standalone kids and children's kind of online privacy bills this year. There's been a trend over the past couple of years of states passing bills that focus on the children's online experience that blends issues of privacy, product design, and safety. Sometimes actually in kind of conflicting ways. So not necessarily true privacy bills, but often legislation requirements that end up with the privacy, legal, and compliance people at companies. So states have been passing bills requiring age verification or passing age-appropriate design codes. And up until this point, the trade association NetChoice has been very effective at successfully getting these bills enjoined or struck down, typically on First Amendment grounds. However, it does seem like we're getting towards a point where so many of these bills are being passed, they keep iterating and trying to improve on prior models that were struck down, that we could end up seeing a child online privacy and safety model that will stick, or at least not get struck down in its entirety. This is also the year that we're really starting to see both state governors and attorney general's offices step up and actually endorse some of these children's privacy-focused bills. In Nebraska, we have what I would call an Age-Appropriate Design Code 3.0 framework endorsed by the Governor and Attorney General's office. In Washington State, you also have a bill endorsed by the Governor and Attorney General's office that pulls together provisions from multiple different previous online child privacy and safety bills. Both of those are worth watching very closely. New York last year passed 2 children's online privacy and safety bills. They are currently in a rulemaking process for that. They've yet to issue draft regulations, but worth watching very closely when those draft regulations are released. And then we'll also point out that what I would consider an age-appropriate design code 3.0 framework just passed the South Carolina House unanimously last week. So we see states continue to iterate and build on child online privacy and safety requirements, and we're at a stage where there's still a great degree of experimentation in the states when it comes to these issues, meaning that if you're in a compliance situated position, those kind of patchwork, those differing or conflicting potential requirements is an issue that is going to be weighing very heavily on your mind.
Fantastic. That's great. Thank you for those insights, Care. Kelly, turning back to you, it's quite clear that these changes will require businesses to adopt a flexible and proactive compliance strategy. What would be some practical considerations that you would recommend to help businesses achieve regulatory compliance across multiple states?
So I have a couple tips to share, I think, and ones that we work a lot with clients kind of on some strategies. I think the first one is to start with the privacy policy and take a breath and take a holistic look. That is your kind of statement to the world on how you're complying with these laws, and maybe more importantly, statement to regulators who might be trying to assess your practices from the outside in. When there were only a few states at a regular cadence, folks had a California section, and then they added a reference to Virginia, and then they added a reference to Connecticut and Colorado. But we're past the point of just grafting new states on to that kind of state law section. So, take a step back if that has been your historic approach, and see if there's sort of a fresh way to provide a more uniform, simple, holistic kind of statement to the world about how you're complying. And as I said, the laws are still uniform enough that you probably could take this approach, although you would end up, maybe possibly over complying in some states. That's what leads me to my second tip. So external compliance is one thing, or what you say in your privacy policy, but back-end differentiation is still allowed and appropriate. So to the extent you can streamline operations and standardize them, like using one web form and not email as an intake for requests where folks can kind of type whatever they want and you're not going to get uniform information from folks. Again, if you can steer consumer rights requests toward standardized intake, if you can simplify your contract compliance to, as much as you're able in your position to sort of make those obligations uniform and consistent, that's going to simplify all of that compliance. And then you can always differentiate on the back end. So as long as your privacy policy is clear that you're going to apply rights, where they're applicable to requesters, you can sort of say, hey, you have a right to access, but in certain select instances, if for whatever reason you choose not to extend it to someone where you're not legally required, I think you still have that flexibility. So kind of standardize external compliance with back-end differentiation if that's appropriate to your organization or consistent with how you want to treat this body of laws. This leads me to an area where there's a lot of friction and wrinkles and sort of the law of unintended consequences, where I hear most from organizations around rights requests. The ones that are legitimate are relatively easy to deal with, but it's kind of the rise of third-party bots or technology that send spam requests en masse that are a really challenging area for companies and organizations to deal with. So, again, it might be really simple to just put an email address in your privacy policy as one of your methods of submitting requests, but again, consistent with what different state laws require, that might get picked up by one of these third-party services, and you might find yourself in receipt of 30,000 requests for deletion, most of which are not from real consumers who have interacted with your business or your organization. So, I urge everybody to just think through how they're going to deal with that. Does automation help with dealing with those kinds of requests? Like if you're still the type of organization where your operations are, we have to go manually query 5 different databases to see if we have any data about this requester. Think about ways to streamline that process and to make it less burdensome on your internal operations. 2 more, I think. So I know that it's like, oh no, there's another law that was passed, and it's very hard to keep up with the news. It's probably why we have such a great audience on this webinar today. But the laws do hit at fairly regular cadences. There tend to be a bunch clustered at the beginning of the year. And then, another kind of cluster midway through around that July 1 timeframe. We've seen a little creeping into October, but there is some regularity to the calendar of when these laws go into effect, even if they're being passed all the time. So if there's a process that you could develop internally to keep yourselves up to date, these laws do have some lead time. There's no need to furiously make changes at the last minute. But to project out, if you have a privacy working group or a stakeholder group that engage, that gets engaged anytime there's kind of a new law, just to double check your processes and make any changes, you can schedule those kinds of meetings at regular quarterly or mid-year biannual intervals to keep this process manageable and relatively predictable. So I always urge clients who are really in a bit of a tizzy to take a breath and to say that this process so far, again, knock wood, has been a little more predictable maybe than it seems on the outside when the news is really coming, flying in fast and furious about bills proposed and such. If you're really in a compliance mindset and not following the policy developments, there is a regular cadence and you can get your arms around a process to deal with these in a relatively systematic way. And then the last thing I would say is don't forget about the other laws. I know we're told all the time, I have clients all the time that say, oh gosh, well, our standards on GDPR, it's the strictest in the world, right? We only have some tweaks. I offer for the good of the group that it is not the strictest in all respects any longer. And sort of, keeping that mindset top of mind for your organization, I think is really important. Like there are innovations in US privacy laws that have to be dealt with and considered in a way that escapes from those frameworks. In a similar way, the sectoral specific laws still matter. They matter in terms of providing exceptions for state laws. But that data doesn't mean it's not, when it's accepted, it's not unregulated. It's just there's a different regime that applies to those laws, and compliance for those sectoral specific laws that you put into place, it needs to be brushed up on a regular cadence, just like your state law compliance work. I know the system is a little awkward, but those exceptions are intended, right, to regulate this data by other means. And, taking some time to understand how all the pieces fit together and sort of putting all those updates on a regular cadence, I think is really important to having a holistic privacy program. So that's a solution I always advocate for with clients, to not just chase the latest developments, but when you have a moment to take a step back and try to just build an internal governance process to deal with all of this in due time. It will serve you well long term.
That is such a great advice, Kelly, and some very useful tips. So thank you for that. We want to start closing the session with some final thoughts. As Kelly was saying, we are looking forward to more new comprehensive privacy laws to be enacted this year if the trend that we saw last year continues. Also, as Kiri was explaining to us, we are looking forward to see the direction that the data minimization standard is going to take and how things turns out and how these standards are interpreted by companies and regulators as well. And we are also keeping our eyes open for new amendments for current privacy laws, specifically for new requirements that are specific to certain types of data, such as children information, biometrics, and also neural data, synthetic data. So we're looking forward to see what happens with those. Are these various privacy regulations applicable to businesses? Does consumer include business organization? Not quite sure.
I'm happy to try to tackle that. If I think I understand the question, it's, is sort of professional or business contact data considered quote unquote consumer data for the purposes of these laws? And the answer is largely it's not. I know that regime is different in other parts of the world, but we still, for the most part, kind of preserve that distinction between someone's, professional or HR employee identity and their personal identity, with the big exception being, of course, the CCPA in California. So it's worth keeping track of if any other states decide to follow California's lead. but I'm not aware of any yet. Kier, maybe you are.
Yeah, and kind of some of the legislative backstory to California, a very unique process. Kind of the rumor is that California didn't necessarily realize they were applying the consumer privacy law to employee data when that law first passed. They tried to amend it a couple times, but didn't get over the finish line. But I will point out that the precise amendment to the Colorado Privacy Act last year, establishing standalone protections for biometric data that we mentioned earlier in this call, does apply to employee data as well. So potentially a bit of an emerging trend there, and we see state lawmakers seek to expand the scopes of these privacy laws in many ways, and moving from a entity level GLBA carve out to a data level GLBA carve out is something I'm paying very close attention to this year. Kind of Minnesota and Oregon were kind of leaders on that. It's in California as well, but now we see amendments in Connecticut and Montana this year that would do the same thing.
Another question we have in is, what is the biggest difference you're seeing between states regarding what is considered personal information?
In terms of personal information and not sensitive information, because sensitive we see many different directions. For personal data, it is mostly that kind of European standard. Is it information that is linked or reasonably linkable to an identified or identifiable person? The biggest standout is maybe Oregon, which includes kind of devices or household level information in that standard potentially. And then another big part here is the states that do include a concept of pseudonymous information and will carve some requirements under the laws out for pseudonymous information. It's a concept that doesn't exist, I think, in places like Tennessee and Oregon, and Oregon, and has different impacts in different states. So in terms of just pure personal data, those are some of the big ones.
I want to thank everyone to joining us today for today's webinar. And thank you for our speakers, to Kelly and Kier. Thank you so much for joining us, Reedy. And you provided great information to our audience today, and have a wonderful day.